So again, I'm just a simple country lawyer, but I would think that an attorney in New York City would not be screaming at a woman who is saying his client raped her. And time again, as E. Jean Carroll was telling the jury this just horrific story about how she was raped, Joe Tacopina was berating her, yelling at her. The judge repeatedly had to call him off. It's not this rape, this trial involving a possible rape not going well for Donald Trump.
Well, yeah, the accounts from inside the courtroom from people who were there yesterday is that Joe Tacopina, a familiar figure to a lot of people because he's been representing Donald Trump in the other case in Manhattan, was effectively harassing E. Jean Carroll on the stand as she told the story of what she says happened to her in the 1990s in that dressing room with Donald Trump. And the judge finally stopping to admonish Tacopina and say, hey, you'll have time to make a closing argument. Now is not the time for that. Sort of him chiming in and interrupting E. Jean Carroll throughout in a way that the judge thought was argumentative. So by most accounts, it was pretty ugly in that courtroom yesterday.
Danny, you are neither a country lawyer nor are you mediocre like me. So perhaps you can just verify for our friends at home. Not good to yell at somebody who could have been a rape victim on the stand.
I've cross-examined victims like this. It is really, really difficult, and you have to be very careful. It's one thing to cross-examine a cooperating witness, someone who is a criminal testifying against another criminal. Then you can lay on the fireworks. But when you're cross-examining a victim of sexual assault, you have to be extra careful. You still have to explore things like their ability to perceive, their memory, whether or not they're motivated by something else.
Right.
And of course, in this case, and it's not a fun thing to talk about, but you have to explore why she took so long to report this. And we know now that victims of sexual assault often never report because of fear of reprisal and things like that.
And she said, I mean, it's pretty easy, Elise. She was scared.
Sure.
I mean, what is the percentage of women who are victims of sexual assault, sexual abuse, rape, that will not respond because they don't want to go up on the stand and be abused by the rapist's attorney?
There's so little incentive for women to put themselves through that and to go on the stand. Yep. There are so many questions of judgment surrounding Donald Trump's choice to attack his accuser throughout this process. But number one, Danny, why doesn't he have a female lawyer?
That would be a good strategy. You're absolutely right.
When he's not even showing up.
Well, yes, and in a civil case, you don't have to. Right. But, my theory here is that Trump is essentially conceding this battle because he knows that he already had a deposition. That's when you sit down, you're under oath, and you give a wide-ranging, essentially an interview, but you're locked into your testimony. And the way Trump's team probably sees it, far better to take my deposition if I'm not there, show the jury the video, even cherry-pick the good parts for the plaintiff. That is far preferable than me taking the stand in open court and letting a plaintiff's attorney take shots at me. And so if that means he loses the civil case, fine. He probably thinks he's losing a battle, but in his mind, winning a political war.
But Willie, you know what he can't cherry pick? He can't cherry pick the Access Hollywood tape, which basically reveals what his attitude has long been toward women. And, of course, I think that's one of the reasons he didn't want to be in there, because he was going to have to confront his own words. He was going to have to confront his own actions. And, again, right now, think about it. We talk about all these other cases that are going on right now. This may be a civil case, but this is a case involving Donald Trump raping somebody. We talk about payoffs to porn stars. This is a case where he has been accused by E. Jean Carroll of rape. He's not even showing up. His lawyer screaming at the possible rape victim, and it's not going well.
It's not going well, and that Access Hollywood tape, by the way, is admissible. It can be used in this trial, therefore likely will be used in this trial by E. Jean Carroll's lawyers. The tone, Danny, and I'm curious what you think of how this settles out, because it is a civil case and the standard is different. The tone from Joe Tacopina yesterday was why didn't you scream? If this was so bad, why didn't you scream out? She said, I was terrified. I didn't know what to do. You know, all the things that rape victims are often harassed about. We heard in that courtroom yesterday. But what is the bar here for a civil judgment, unlike a criminal trial?
It's preponderance of the evidence. It's probably the only burden of proof that can be expressed mathematically. Beyond a reasonable doubt is the highest standard. It's our criminal standard. It is, you know, as lawyers like me will argue in closing, it's such a high standard. It doesn't mean beyond all doubt. It just means if you hesitate, the way you might when you're looking at possibly buying a house or something like that. But preponderance of the evidence could be basically 51% because it's more likely than not, or it's more accurately 50.00001%, whatever tips the needle one way or another. So it's a much lesser burden, much easier to make out. That's why so many civil cases settle, because defendants know they're facing a very difficult burden, and they'd rather manage that risk and end up paying money they know that they can quantify today, rather than just some runaway jury's verdict later on in the future, and then they have to spend more money appealing it. So the burden here is much lighter. But, you know, I have to say, the tone maybe could have been changed, but a defense attorney in a case like this, whether it's criminal or civil, because this really it mirrors a criminal case, he has to explore the credibility of the victim on cross-examination. He has to do it. Now, the way you do it, you have to be nuanced. You have to be polite. You have to be respectful of the witness. So that's the key. And if you don't, the jury's going to see that, and they're not going to like it. So it is a needle you have to thread. And I got to tell you, it is hard to thread that needle. I've done it myself. I don't know if I've done it successfully, but it is hard.
And Rev, you know Joe Tacopina, you know the attorney very well. He didn't thread any needle yesterday. He just kind of kicked open the barn door and went in.
Yeah, I was surprised at how aggressive he was. And as particularly given his client, who he knows has a tape out there, saying, you just grab him.
Right.
I mean, if you want to indict yourself, just play the tape. And
he's laughing about that. He's admitting
he's instructing somebody how to do this.
He says, this is how you do it.
This was not Joe's best day. Let's put it there.
No.